All right. Welcome aboard, ladies and gentlemen, joining this call. It's 1 minute to the hour of 2 p.m. So thank you for keeping time. We should be starting our session shortly. In the next 1 minute, we'll be going live, but let's use this opportunity to share this a link with members who may want to join this session. We are privileged to have our panelists on call. So in about a minute or two, we'll be officially starting this session. So let's take this opportunity and get to tweet and share on the different social platforms. And I hope you're doing well wherever you are listening in from. And we really, really hope to have a very interactive session this afternoon with you all. So we are now live, and on behalf of the East Africa Law Society, would like to welcome you all for this very action-packed session that is going to delve so much in discussing sports dispute resolution. And on this panel, ladies and gentlemen, we have an eminent list of panelists who have distinguished themselves that is going to going to really shape our minds as lawyers interested in the practice of sports law, given the fact that East Africa is at a very important stage of hosting the AFCON. Now, ladies and gentlemen, this afternoon, we're honored to have our moderator being Mr. Philip Munabi. Mr. Philip Munabi is an advocate of the High Court of Uganda. He's largely a transactional lawyer, and his core areas include corporate and commercial law, capital markets, projects and infrastructure, regulatory compliance. He also handles criminal matters, but distinctly, he has shaped a niche as one of the most powerful sports lawyers that we are getting to know in Eastern Africa. He also serves as vice chairperson of our sports law committee. He serves as the Secretary General of the Uganda Law Society, and most recently, he was appointed commissioner of the Uganda Boxing Federation. Mr. Munabi, we are profoundly honored to host you once again, and I'll hand it over to you now to introduce your panel and take on the discussion till 4 p.m. Welcome, sir.
Thank you, Gabriel, and the East African Law Society Secretariat for, first of all, acknowledging that among the specialized areas of practice is sports law. And out of that, we have had so many discussions. I think at the ELS AGM, Pauline and Senior Counsel were on the panel. I think Pauline and Senior Counsel could not have been on it, but there was a panel that had Pauline and Dr. Don. It was a very wonderful panel. It set the pace for the discussions this year, and I am glad that in this first discussion, we surely have the cream of the crop in sports law across the region and the continent, if I may say, because we have panelists from as far as Nigeria. Today's discussion is about sports dispute resolution, specifically dwelling on how lawyers can use ADR win away from courts and lengthy dispute resolution mechanisms. Our panelists, for most of them, I'll just introduce the names. Senior Counsel John Ohaga has a very huge profile, which I think you cannot miss in arbitration. He just took us through 3 days of commercial arbitration in Kenya, South Africa, and Nigeria. It was very wonderful. The only thing that he did to us that disadvantaged us was that much of the authorities, him or his partners, had instructions, so he couldn't comment on them. But he's a distinguished legal practitioner. He has contributed tremendously in all fields. I thank him for one thing. Whenever you call upon him, he's always ready to present or share something that he has experience on. He is a judge. I think he is still a judge of the Sports Tribunal of Kenya. There's much about him, but off LinkedIn and social media platforms, you can get his detailed profile. We also have Dr. Farai Razano. Dr. Farai Razano, not to bias, but to brag, is one of my lecturers who will be taking me through international sports law at the Academy of Leadership Sciences in Switzerland. And out of networking and these discussions is where I got the opportunity to have a scholarship to do my master's in international sports law. So very soon I'll be joining the League of Men, but he's a distinguished legal practitioner and international sports lawyer whose profile is also readily available on different social media handles. He will be taking us through an area that will have a topic called arbitration in action. What are the best practices for resolving doping, eligibility, and commercial dispute in sports? You'll all understand that doping is one area that is also large and huge in sports. It has a lot of disputes around it, but it's a critical area that you can even specialize in as a sports law practitioner. That will be handled by Mr. Razano Farai. Dr. Emmanuel Oluwafemi Olowoni. I want to confirm that you're there, Doctor.
Yes, I'm back. The network is fluctuating, but I'm back. I'm here.
The last session I had with you was on AI in sports.
Artificial intelligence.
Yes, and I want to report that in February I went to Nigeria and I registered my presence in Kalakuta Republic. Yes, Doctor. So, Doctor is a distinguished legal practitioner. He's a lecturer at Nigeria Law School. He will be taking us through the future of ADR in sports, adoption to technology, equity, and global growth emerging trends, esports expansion, and the evolving rise of dispute resolution. He's passionate about this area. When you look at most of his papers, he highlights some of these areas that he's going to handle. He has written detailed papers around them.
Okay, please, yes, I'm back. If I could have a little.
Yes, Doctor. So Doctor will take us through that area as I was informing you members. And lastly, but not least, and most important, we have a female panelist today. Pauline Banza is an international sports lawyer. She has a very good profile. She started with Max Advocates here. She went to work with Beverly. Let me get the law firm right, a Nigerian firm. OAL, where she left and then joined Real Madrid. So for the listeners, we are having Pauline, who has worked with one of the most prominent teams in their legal department. She has seen and had these contracts that we hear of in the news of CAF, and she will be she'll be sharing her experience, taking us through negotiation strategies, securing win-win deals in sports transactions, mastering leverage and multi-party dynamics. And most important, the partner negotiations in sport. What's the best alternative to your negotiated agreements? That's what she'll be handling. She's a very experienced sports law practitioner. Those who follow her on her social medias, I think she does a weekly. Most times I read it weekly. She has a weekly. I don't want to call it blog, but she writes about European football and banter. She gives detailed profiles of players. She writes history. She comments on current affairs. So that is what we shall be looking at, or what she'll be taking us through. But to start off the debate right now is Senior Counsel John Ohaga. I already gave his profile. His topic is why ADR wins in sports, the advantages over litigation in high-stake industries, mediation mastery, and facilitating fair outcomes in athletic team conflicts. Doctor, as you take us through, as you come on board, we will also need to understand which disputes go to CAS, because much of the household names and issues here is any arbitration goes to CAS. Which issues go to CAS? When we had just started organizing this session, I think Yanga FC had filed a matter before CAS. They had they needed 3 points for a match that had been postponed, but I think by 2nd of May, CAS had dismissed that claim. So which matters go to CAS? Which matters come for arbitration? How should a lawyer prepare himself? What qualities, what qualifications, what is required to have matters resolved? Doctor, also in your discussion, please highlight to us, let us understand how you have handled arbitration at your sports dispute tribunal in Kenya, which matters have come to life, and any lawyer who is interested in sports law can interest their parties into adopting ADR as opposed to court litigation. Thank you, Doctor. Thank you, Senior Counsel.
All right, thank you very much, Philip. Thank you. As always, it's my pleasure to join you this afternoon. Sports is a passion for me, so speaking about sports is something I take great pleasure in, and I'm very happy to share my experience. So Philip, my term as chairman of the Kenya Sports Disputes Tribunal came to an end in November of 2024. So that has ended. But shortly after the end of my term, the Minister for Sports appointed me to chair a task force whose role is to review the sports policy and the legal and institutional framework for sports in Kenya. So we're presently involved in that, and I'm trying to bring my experience from the Sports Tribunal to bear on reviewing Kenya's sports policy, as well as reforming our legal framework. And I hope that we will be able to do that effectively. But this afternoon, I'm specifically asked to speak about advantages of mediation over litigation, and specifically for the purpose of facilitating fair outcomes in athlete and team conflicts. Even though I don't think it would be limited to athlete and team conflicts, I will try and use some examples from my experience as chair of the Sports Tribunal to demonstrate why mediation is best suited to resolving disputes of that nature. But first of all, I think we need to contextualize why we're gathered here this afternoon to speak about sports. And the reality is sports is becoming a global industry, generating billions and billions of dollars. And as East Africans, we need to get involved, we need to equip ourselves, and we need to participate in the sports industry. As you know, East Africa will soon be hosting significant football tournament and continues also to host other sports. And on the global scene, East Africa continues to be very active, churning out athletes, especially in athletics, where Kenya is a powerhouse. Uganda is churning out athletes as well. And Rwanda, as you can see now, is sponsoring Arsenal. So we really are trying to participate in the global sports industry, but we do need to skill up. And so hopefully this forum is part of skilling up. So because I have limited time, I will go quickly into the question of why ADR is better suited than litigation. In order to understand that, we have to conceptualize what ADR mechanisms we are talking about when we speak about sports. And the ADR mechanisms available in sports are mediation, as you know. Mediation, as you know, is voluntary, and it is also interest-based rather than, it is interest-based. It doesn't focus on rights. It focuses on interests. Arbitration is conducted through various institutions such as CAS or local sports tribunals, which conduct arbitration in one form or the other. Specifically, I will tell you the jurisdiction of the Kenya Sports Disputes Tribunal is actually to arbitrate over sports disputes. So the anticipation is that the Kenya Sports Tribunal would use arbitration mechanisms in order to resolve sports disputes. And then there is, of course, negotiation, because negotiation is a recognized form of ADR. And negotiation is informal, and it is often unstructured. Focusing specifically on litigation, vis-a-vis ADR as a mechanism for resolution of sports disputes, I want to highlight certain aspects, and those of you who are litigators or in the dispute resolution space will immediately agree with me that litigation is time-consuming. Litigation has inherent delays, and I accept that whilst more and more of our courts and judges are becoming specialized in different areas of dispute resolution, sports is not yet one of them within our court structure. So there is also a lack of depth of specialization for the resolution of sports disputes. On the other hand, athletes have relatively short careers. Athletes require certain psychological makeup in order to be able to perform at their best, to achieve optimal performance. Athletes want a serene environment which promotes optimum performance. Litigation does not lend itself to that because litigation inherently has anxiety built into it, and the delays in litigation, the lengthy timelines, are just not conducive to the resolution of sports disputes by litigation. Also, litigation is held in the public because court processes are often public, and so there's a risk of reputational harm. And you will appreciate that reputational harm could potentially impact athletes' performance, athletes' earning ability, and athletes' relationships as well. Our litigation has rigid procedures. Those rules, as you know, our civil procedure rules, we are rule bound. And so we have to cite the specific rule. We have to present our pleadings in a certain form, and we have to address the judge and opposing counsel in a certain way. All of these are actually ill-suited to the unique demands of sports. And so when we look at the comparative advantages of ADR, you will appreciate very quickly that mediation has quicker timelines, especially in relation to matters such as selection and matters relating to eligibility. I have also found that in relation to commercial disputes, mediation is best suited, and I'll very shortly give you one or two examples. Confidentiality is protected because mediation is held within a confidential environment, which will protect athletes as well as team reputations. The flexibility that mediation allows you is one that you can exploit to customize your procedures, meeting places, forums, and so on and so forth. And also mediation allows you to deploy industry expertise. So you can, in your mediation panels or in your selection of mediators, you can select sport-specific mediators or arbitrators so that they have an insight. And in fact, you can go beyond that so that they're not just sport-specific, they are specific to the particular sport in which the dispute has arisen. So if that sport is, for instance, boxing, you can have mediators who have specific insights, experience in boxing, the rules, the custom, usage, all of these nuances, relationships, all of these things are integral to the resolution of any dispute. And of course, when you think about team dynamics, when you think about continuation of careers in sports, mediation is able to preserve these relationships, is able to overcome the tensions that arise when disputes arise, and allow athletes, allow federations, allow coaches and managers to restore their relationships in order to move forward. So in order to demonstrate that, and because of the limited time, I want to just give you two examples that I was able to experience success in utilizing negotiation and mediation in the resolution of sports disputes. So when betting companies first took an interest in sponsoring sports teams in Kenya, there was one team which had a dispute, and because this is public, the team was a team called AFC Leopards, and there was a dispute relating to the leadership of the club. There were two factions which were seeking supremacy in leading the club. And so the two factions were approached by two different betting companies. One faction was approached by SportPesa. Those of you in Kenya, and I'm sure across East Africa, will know SportPesa. And the other faction was approached by Betway. Now, both factions signed sponsorship contracts which designated the betting companies as the exclusive sponsors of the club. And so the value of the sponsorship contracts were actually the same. One betting company promised 20 million and the other promised 20 million. Now, you will, as lawyers, readily appreciate that you cannot have two betting companies which are the exclusive sponsors of a football club, because exclusivity means they are the sole sponsors. And this became a matter that was untenable. We were very quickly approaching the beginning of the season, the football season, and this matter came before the Sports Disputes Tribunal. And it became very clear to the tribunal that we could not resolve this through your usual litigation or arbitration mechanism, which would entail parties framing their cases, arguing, seeking adjournments, and eventually waiting for a ruling. And so we decided that mediation was best suited to resolving this dispute. And so I was designated as the mediator. And so I invited both factions into the room, and I invited the factions as well as the betting company that was supporting each faction. And they came into the room. I actually invited them into the boardroom at my law firm, and I asked both betting companies to, because their financial offerings were equivalent, I thought that perhaps if they offered, if they were able to demonstrate what they would bring to the club by way of branding, by way of best practice, by way of fan engagement and so on, that the two factions would then be able to make a rational decision. And so they both came here and they made PowerPoint presentations. And again, you can see how this would not have been available in litigation, because the betting companies would not have been parties to that litigation. But being a mediation, I was able to determine who should be in the room. And so they brought in their marketing gurus and they made their presentations. At the end of the presentations, the two factions were still unable to agree which presentation was the best, even though I could clearly see which presentation was the best. And so what I then did, and this is where there's a, you have to find a way in which to leverage the authority that you enjoy in a certain environment. And so what I then did was, as chairman of the Sports Disputes Tribunal, I announced to the public, I announced that I had cancelled both betting contracts that had been awarded to the club. And this then threatened to ignite litigation, because both betting companies then threatened to sue. But my question to them as a litigation lawyer myself was, well, who are you going to sue? Are you going to sue the club? Are you going to sue the tribunal? What I would like to do is to invite you to refresh your offers to the club. And so they began a bidding war. So the chairman of one betting company called me up and said, okay, Mr. Chairman, and I'm now paraphrasing what happened, and said, Mr. Chairman, okay, we have had you, we're prepared to increase our offering by 5 million shillings. When the other betting company heard that the rival had increased their offering, they also increased their offering by 5 million shillings. And this went on, and I can tell you this went on over a very short period, over 6 hours. I took fresh bids, continually increasing bids, until one betting company got to 40 million shillings. And the other betting company said, well, we are unable to match what has been offered by this other betting company. The result was, through mediation and negotiation, I was able to raise the amount of sponsorship for this club to double it, really, from the time this dispute arose, through the mediation to the bidding war. And so you can see how you can leverage this in order to also increase the benefits to the sporting organization. If we had deployed litigation or arbitration, our simple, narrow role would have been to determine this dispute and to determine which of the betting companies should be the official sponsor of the club. And that would have been based on the contracts they entered into, and there would have been no additional financial benefit except what was within the pleadings by the parties. And so with an outcome that everybody was happy with. It's more intricate than that. It's a long story, but the long and short of it was that SportPesa became the official sponsor of AFC Leopards at the princely sum of 40 million shillings. which became the highest amount that a club had been offered at that time by its sponsors. And so we were able, through mediation and negotiation, to achieve an outcome, as I said, that was hugely beneficial to the club. And of course, I thereafter supervised the drawing up of the sponsorship agreement and ensured that there were the necessary protections on both sides, and so on and so forth. The second dispute that we were able to successfully deploy mediation in related to a dispute that arose within golf. As you know, Kenya hosts what is called the Kenya Open Tour as part of the global golf touring circuit, which attracts very, very high-profile golfers, and which has a very significant impact on the Kenya economy, just because of the number of golfers who come in, their entourages, the hotel accommodation they enjoy, and the ripple effect that the economy enjoys. Now, this tournament threatened to, the World Golf Association was threatening to bypass Kenya because there were two factions fighting for supremacy in Kenya. Now, under the Kenya Sports Act, and again, very quickly, there was a requirement that sports organizations should transition and register themselves as sports organizations under the Sports Act. And so there was the Kenya Golf Union, which was the federation that was responsible for organizing sports prior to the coming into being of the Sports Act. However, because of the politics of sports, what happened was that a different federation, which called itself the Kenya Golf Federation, very quickly registered themselves as the federation responsible for golf in Kenya, and therefore sought to hijack the tournament. But you see, the problem was, under Kenya law, they were now the legitimate sports organization responsible for golf in Kenya because they had been registered by the sports registrar. And so they appealed to the sports tribunal to give them or to confirm that legitimacy. Now, I very well understood that while they were the de jure organization responsible for sports for golf in Kenya, as being the registered federation, I was well aware that this was a federation with no followers. There were no clubs, there were no golfers who were members of this federation. In fact, the de facto federation that was responsible for golf in Kenya was the Kenya Golf Union, which now no longer had legitimacy. Now, if we had determined this appeal on the basis of pure law, the Kenya Golf Federation would have won the appeal, would have been the legitimate body responsible for running golf in Kenya. However, that outcome would have been disastrous for golf in Kenya because the Global Golf Union did not recognize the Kenya Golf Federation and only recognize the Kenya Golf Union, which would have meant that the tournament for that year in Kenya would not have been hosted in Kenya, and essentially Kenya would have lost out. And so I determined that we should resolve this by mediation. We went through various iterations of mediation, reduced the temperatures, and eventually came to the conclusion that what was needed was to hold an election so that that election would essentially bring into place legitimate officials of the Kenya Golf, the Kenya Golf Federation. And once the legitimate officials were voted into office, they could very quickly transform the union from the federation into the union. And so we put in place an abridged timetable for elections. And of course, you can guess what happened. What happened was that the officials of the Kenya Golf Union won the elections because they had the following within golf. The officials of the Kenya Golf Federation were being paper tigers because they only held the certificate. And in that way, we were able to salvage the Kenya Open Golf Tournament and to allow it to proceed by deploying mediation and being able to very quickly resolve the dispute in an innovative way within a very, very short period. And as some of you might know, golf was during President Kibaki's time. President Kibaki was himself a golfer, and so golf had a certain prominence in Kenya. And President Uhuru similarly supported golf because of its social connections and because he very much enjoyed the 19th hole in golf. And so the president was very pleased that the matter had been resolved in that way. So mediation is without a doubt in high stakes sports or athlete disputes what needs to be deployed in order to achieve an effective resolution of disputes of that nature. You can also deploy mediation in contractual disputes in relation to commercial arrangements, in relation to image rights, in relation to, I've already spoken about sponsorship deals, and any nature of commercial undertaking that you can think of in sports is amenable to resolution by mediation. Selection disagreements are also amenable to resolution by mediation because you can facilitate compromise between athletes who are competing for positions. And again, at the Sports Disputes Tribunal, we have deployed mediation to try and resolve issues of that nature. Allegations of discrimination and unfair treatment, which are often central in selection disputes, are amenable to mediation. So mediation works because the mediator facilitates dialogue without imposing a solution. And so that solution is driven by the parties. And so parties, therefore, are empowered, they own the resolution, and therefore that solution which they come to is one which will transcend the dispute and enable them to carry on. And therefore, essentially, you are upholding athlete autonomy. Because it focuses on interests and not rights, you can explore the underlying issues, such as I've been able to try and demonstrate we were able to do in the two examples I've given. And there are many, many more examples in which we have deployed a mix of mediation and negotiation to actually advance career progression, to advance team harmony, and to ensure that there was a timely resolution to those disputes. Because I'm running out of time, I want to quickly run through what outcomes you should expect from mediation. Mediation builds trust, it builds credibility, it has outcomes which every party can embrace and therefore own. Because of the confidential nature of it, you can undertake confidential shuttle diplomacy, which is really what I undertook in the dispute relating to the sponsorship between the two betting companies in order to elevate the amount of their sponsorship. You can also be able to appreciate where there are cultural differences or where there are reputational concerns to which the parties are sensitive. You can take those into consideration, understand them better, and allow an outcome that, that the parties can uphold. And so what do you need to do in order to be able to be an effective mediator? I'd like to say that you need to train, upskill your mediation skill set. But in order to appreciate the benefits of mediation, my own view is that if all you know is mediation, then you are an incompetent dispute resolver. In order to be able to understand the effectiveness of mediation in a particular dispute, you need to understand it vis-a-vis the other methodologies for dispute resolution, such as litigation, such as negotiation or arbitration. You need to be creative in crafting your agreements in whatever nature of sports contract you're drawing, so that you build in ADR clauses, whether in sports contracts or in disciplinary codes, so that mediation becomes available, and mediation then becomes something that is accepted as part of the philosophy of dispute resolution within sport. You need to appreciate that mediation is not a weakness. It is actually a pragmatic strategy. You know, sometimes when parties come to us because they are in dispute, all they see themselves is as being in an adversarial position, and they want to slug it out, and they want to win because, you know, a sport is very competitive, athletes are competitive, federation officials are competitive. Everybody wants to win because that's the objective of sport. But you need to educate sports people, everybody within the sports ecosystem, that when it comes to the resolution of sports disputes, it is not about winning in the boardroom or in the courtroom. It is about winning on the sports field. In the boardroom, in the courtroom, in the tribunal room, you need to be strategic about finding a resolution that is sensitive to the timelines within which sports operates, to the emotional context and psychological context within which sport is played, to protect the reputations that are involved in sport, and to ensure that relationships are protected. So I want to stop there, Philip, because I know that I've taken longer than the time that you assigned me. And if there are any questions, I'm happy to take them later. But I would also like to listen to my esteemed co-panelists and to learn from them. Thank you very much.
Thank you, Senior Counsel. Of course, you have questions already in the Q&A. I've seen a question by prominent criminal law practitioner, but very passionate about sports law practice here, Mr. Henry Cunha, senior advocate. He has a question on how willing stakeholders are to embrace ADR in sports-related disputes. There's also another question on whether it is feasible to legislate on mandatory ADR regarding all sports-related disputes. Maybe, as you presented, Senior Counsel, when you react, I would also want you to make us understand. I'll give a very feasible situation. Here in Uganda, we have the new Sports Act and regulations. They provide for arbitration of sports disputes. They have not provided for mediation. Even the reference to CADA rules under the Act, I'm not certain that the CADA rules provide for mediation as an alternative dispute resolution or mechanism in sports disputes or sports-related disputes. But you'll help us understand more how to go about it. Can I put up my practice in mediation as a sports dispute mediator? If I have trained and if I have the relevant skills, can I go that direction as a legal practitioner? We will also hear from next, which I'll call you back, Senior Counsel. You can reflect on the questions. And let's also hear from other presenters. And I think I'll call upon Pauline Mbaza to take us through an understanding of negotiations mainly. Pauline handles, she has handled and advises on critical contracts in commercial sports, commercial sports related contracts. She has handled those, and she has an experience on offering what will be the best alternative to the negotiated agreements. We have agreed on this. There's a conflict right now. There's a dispute. We don't know what to do. Should we go to court? Should we go before an arbitrator? What would be the best alternative to your negotiated agreement? That is what Pauline will take us through today. But like I promised, we will be holding more conversations that she started at the AGM, the ELS AGM. This is the conversation we had, and she was part of the conversation that opened up the whole calendar of how we shall move through this year. Please, Pauline, you're welcome.
Thank you very much, Philip. I'm pleased to be talking about these different strategies on negotiation. So I'm just going to firstly outline that there are things that fall among all the strategies that have been mentioned. That is leverage, negotiation leverage, but now that is best alternative to negotiation agreements, and then also multi-party dynamics. So firstly, what I would like to mention that cuts across is proper communication and formation of coalitions. Yes, so before I go into details of this, I would like to mention that most of the times arbitration is going to happen where there is a conflict, or this negotiation is actually the negotiations are going to happen while there is a conflict, or while you're trying to have a deal. For example, in sports, specifically sponsorship deals, for example, with broadcasting partners. For example, if Malchoice is having a discussion with Premier League, there's going to be different other parties that are going to have to be part of this kind of negotiation, because it's not just Super Sport that is going to have the rights to broadcast that. So this negotiation does not only apply to where there is sports conflicts. That is precisely to maybe mention things like contracts, because mostly that's where the conflicts are going to arise. But to delve into what I'm supposed to be discussing today, I'm going to first talk about the idea of negotiation leverage. Basically, having leverage is one of the most important things in negotiation. So for someone to have the best outcome of the negotiation, or whether it is because of a conflict or trying to have a deal, you must have a leverage. You must be able to understand your leverage. And basically, this is the power that you have in the negotiation, or the advantage that you have in the negotiation over the other party. And for one to be able to understand this, or to be able to use it to their best of their abilities to be able to get the most favorable outcome of the negotiation, they should be able to ascertain things like the information they have, the resources they have, the relationships they have, and then also the alternatives they have. And this is where partner comes into place. But before we discuss about that, these four are very important factors, because when you're able to put down these factors, then you're able to actually work on those to be able to, by the time you're having a negotiation, you're able to use them to the best of your abilities to have the best outcome from the negotiation. So when you know that when you've established that, you can go on to do, for example, the first thing you have to do is to have research. You have to do extensive research. As a lawyer, that's the core, one of the cores of our work that we do. So when you go on and do research about the people that you're going to be negotiating with, it is very important, because you are certain what their weak points are, what their interests are, their needs. Because most of the times we're going to enter a negotiation, and the needs, that the things that are being put forward are basically the ones. For example, in a football negotiation between a club and a player, there is going to be the player wants a higher pay, because, for example, there is a regulation that the player's pay should be able to accumulate over time in terms of increase. So the player wants an increase in pay and a stable salary, basically payment security, salary security, and job security. The club, on the other hand, needs the player to actually be able to give them the services. So when you try to understand the power you have over the person you're negotiating against, for example, in this case, if you're representing the player, you need to understand what the other person has more than you have in terms of their weaknesses or what their needs are, and in this case would be they want the player to give them the best football abilities that he has. So you have to make sure that you have this kind of information to be able to have a proper negotiation that favors and that gives an outcome that favors you. But then again, it's also important to evaluate the resources, looking at what you have on your table and what the other people that you're negotiating with have on their table. Because some parties are going to have more resources than you do, or you're actually going to have more resources than they do. And this may include legal representation, this may include finances, and so many other things that may come into play. So when we evaluate this, you're able to actually know that I'm going to be able to it gives you a better way to strategize. For example, if you're able to get the best legal representation, that means you can actually have the best arguments, the best decisions made for your client, or for the influence, to have the influence in making the decisions. But then also it's important to, or upon learning all these kinds of stuff, it's important to understand how to put down your strategy. There has to be a strategy in which you're going to negotiate. You don't move into a negotiation room and you don't have a strategy. You don't move into a negotiation room and you've not outlined what you're actually going to be looking at. Because once you have gotten the information, once you have evaluated the resources, and also of course, you've already put in place your alternatives when you collect the information that you've had. You have to strategize. You have to look at how you're going to be able to handle the negotiation. That, in any case, saves you time, but also helps you to make arguments that favor you in terms of you've already evaluated this person has this alternative. So how do I actually respond to this alternative that this person is bring on the table? So it's important that you put in place a negotiation strategy, which may, in any case, if the only aspect that is in place is maybe alternatives, you have to make sure that you have the best alternative. For example, in contractual disputes between footballers and clubs, there is going to be a need for you to understand, okay, this club, their alternative is they're going to, they basically will run away without paying the money. And your alternative, which will actually be the best, is that even if they decide to run away with the money, in terms of even if they decide not to pay, you know that you're going to match out of that negotiation, and you're going to have to go to the to higher levels of arbitration. So you're going to take it to FIFA, and if FIFA doesn't favor, you can take it to CAS, that kind of thing. So when you have this kind of establishment of all this kind of information, of course, you're going to have information like for if a club has been not been paying their players on time, of course they're going to know that they're going to hire the best players and every kind of thing. You definitely know how to go on with that kind of negotiation before you reach the point of having to have a judge listen to the case. So that is very, very important. But also it's important to build relationships. One of the ways to be able to win a negotiation is building relationships, and meaningful relationships or strong relationships. For example, if you're representing a footballer, if you're representing a coach, they should be able to identify themselves with the player union or the coach union. Or if you're representing a match official, they should be able to identify with the match official. This is very, very important because it helps you to negotiate even better. Because once, for example, a player identifies with FIFA, if they are a member of FIFA, it is going to be very easy. For example, if that player needs more maternity leave from their club, it's going to be very easy for you to have that kind of negotiation because FIFA is going to support you, is going to offer some resources. This has happened before, and people have actually won. There is a player that was I can't exactly remember the name, but they're playing for a French club, and they needed their leave. They got the leave, but it was not enough. But even when it wasn't enough, they were not paid according to the regulations. FIFA supported this female player, and she was able to actually win the case. But beyond that, the club had to pay because FIFA, beyond the decision of of cards was able to intervene until the money was paid, because sometimes clubs are actually going to abscond from having to execute what they've been told to execute. So it's important that you do that. But then again, and most importantly, is having a negotiation presence. Basically, this is basically looking at the idea of presentation. What is actually happening in the negotiation room? Firstly, is the first thing is professionalism and proper communication. If there is no professionalism, most of the times the negotiation is not going to go through. But then, even if it does go through, you're going to be undermined to an extent that you will not have a favorable outcome. But then, if there is no proper communication in terms of laying down your most important objectives, that means the other party that you're negotiating with is going to undermine your own ideas, your own objectives that you bring to the table. So it's important that there is proper communication, there is proper presentation, but also being able to be confident and lay down what the party wants. If you're acting on behalf or being the one directly negotiating for yourself, it's important to know that I have to be confident with the objectives that I'm going to put across. Otherwise, the other party is going to undermine you. But vice versa, it works. If both parties are actually confident and professional, that means the negotiation is going to go on well and both parties are going to win. And an example is, for example, when you have a club that has delayed to pay salaries for over 2 months and the supply is being agreed, the first steps of this may not be a physical negotiation, but the first step is going to be that you're going to have to send a request to pay for the money. Basically, that is a default notice. You're going to tell them you need to pay this money according to these regulations and everything. But then the other party may not really be professional, and they may not actually listen to your plea to them, and they're just going to move away from everything. But even if they don't, they may actually accept and be like, let us have the discussion, let us have a negotiation and see how to actually pay this. And when you go for that kind of negotiation, the club or the footballer you're representing need to be confident, they need to be very professional, and clear communication. But if that doesn't happen in that negotiation room, two things happen. There is not going to be a clear understanding of the objectives of the party. But again, the negotiation is not going to be fruitful, which means you're now going to have to go on to another level of having to have a judge listen to the case, and then you will have to have a whole session, which is far longer than having a negotiation. So that is very, very important. But upon having all this kind of information, it's important to actually put it in action, like to make sure that, okay, I have this relationship with Fifth Pro, I need to put it in play. I have to now speak to Fifth Pro that I'm actually going to I'm going to have the negotiation with these people and I need their support. But also after understanding that these people's resources, they have this, what do you put in place? You also have to get your resources together. But in case you're not able to, you have to look for a way that you're going to be able to rebut to that, because it's important for you to get a favorable outcome from the negotiation. But beyond this, there is a whole idea of multi-party dynamics. Most of the times, negotiations are not going to just take place between two people or two organizations or two companies. They are actually also going to have other parties, other several parties, and these parties will need to have a favorable outcome for all of them. Yeah, and it's upon you, if you are in charge of the negotiation, or if you're actually representing somebody, it's important for you to understand the power dynamics in those multi-parties. But then again, it's also important, firstly, to understand the parties that are taking place. So the first step towards achieving a favorable outcome in that case will be having a pre-negotiation stage, where each party is going to decide who represents them, or if all the parties are going to actually be present in the negotiation. For example, if there is a conflict or there is a negotiation between a club, an agent, and a player. The player wants to move to a club, or the player has not been paid by the club and has an agent. But then again, besides that, the player also has a legal representative. Now, the legal representative may not be very important in this negotiation. The most important parties here is the agent, the player, and the club. And now, the club may also have an agent. So there is need to understand that who is actually going to attend the negotiation. So in this case, the regulations are very clear that an agent can represent a club and a player. So does the player actually accept to be represented by the same agent that is actually representing the club? So that at this point in time, we decide who is actually going to be attending the negotiations. But then when the negotiations get to kick off, you finally get to a stage where you have to negotiate. It is very important to form coalitions because this actually helps you to have a very favorable outcome. Because if you're not able to establish that kind of coalition, it's going to be hard to have an outcome that favors you. This is precisely because parties often have similar interests, but also have conflicting interests. If you're in a negotiation that has over 5 people, and one party says they're interested in this, another party says they're interested in this, it is up to you as the negotiator, or if you are the chairperson of the negotiation, to find a way with good communication, putting forward what every person's objective is, so that there is a way for each party to maybe align with another party that has similar interests, so that at the end of the day the negotiation is cut shorter, but then all parties get to benefit. But also, most importantly, when there is proper communication between the parties or among the parties, that means everyone gets to understand what the other party's objective is and this other party's objective is. And then that means you can be able to bring in the idea of compromising. If the other party's objective is not really their major objective, that means they can actually do away with it without it. Yeah, so they can compromise on the strategy and they can go on to be like, okay, we're not going to we think we can do away with that, and then that means they get to win from that end and this other party gets to win. But then also, most importantly, is that besides that, there is besides having the clear communication, at the end of the day, alliances are made. But even when they're made, it is important to understand that these alliances or coalitions can actually change or they can fall apart, because during a negotiation, interests can actually change, objectives can actually change. So it's, if you're a representative or if you're in the middle of the negotiation, there is need to be able to strike a balance. Yeah, when such collisions break down, what is the next step? There should be understanding of power dynamics. There should be an understanding of change in strategy. So if this party's interest changes, or if this new information changes, how then do we handle that kind of situation? Does that mean this party goes independently and they all go and we get to a point of conflict, or do we actually find a middle ground? That is why it is important to have the proper communication, because you're able to understand that this party's key objective is this, and then you decide on what to do next. But then, most importantly, because most of the times in multi-party, when we're looking at multi-party dynamics and under negotiation, it may not be easy to come to a final conclusion that favors everybody. So some parties may have to compromise some of their not so important objectives. Some parties may not, and there may not even be a decision that favors everybody. So there could arise a conflict, a bigger conflict, or a negotiation for a partnership may not actually happen. And this doesn't just happen in while there are so many parties that are in the negotiation, but also why it's just 2 parties. And that is why the idea of the best alternative to the negotiated agreements come in. When parties understand their partner, that means they understand that beyond this point, we are not going to exceed. That means we're going to be able to move away. That means we are able to sell our idea better than these people because we have a better alternative. And that is why it is very, very important that in multi-party dynamics, or where there is more than two parties negotiating, this idea is brought across. Because once you're able to understand your partner, it means two things. Firstly, you know when to move away. Secondly, you don't sign something that you don't fully agree to. And thirdly, is that you have a more bargaining or more negotiating power than the other parties. So when you understand that my product is the best, yeah, my party doesn't have a better alternative, you can actually match away without having to sign an agreement that you don't buy into. An example is, for example, sponsorship deals with basically merchandise deals with football clubs, or for example, players with merchandising companies. This is Puma, Nike, Adidas. Most of the times in these negotiations, the club has their partner because they know there are alternatives. They know if Adidas doesn't take us, we're going to go for Puma. If Puma doesn't take us, we're going to go for Nike. And they're all going to give us what we need with the money that we need or we have. You understand that kind of discussion. On the other hand, these sponsors definitely know that there are other competitors because they've already done their research as part of their understanding their leverage. They've already done their research. They know this club has this number of alternatives and other sponsors. So what do we do? And that is when they actually bring you a product that you cannot refute because it answers all your objectives, even your minor objectives. So they give you a standing at which they are going to be able to sell you the product, and then you decide if you want to actually go on with them because they're not going to exceed a certain they're not going to exceed a certain level. They have their lowest point which they go to. So it's important that when negotiating contracts, negotiating between sports entities where there is conflict, there is a need to understand the whole idea of leverage, the power dynamics, but also most importantly, the partner that actually goes through, that flows through all the negotiating strategies. Because without an alternative, if you don't have an alternative, that means you're going to get stuck in a negotiation and going to sign a negotiation agreement that you do not align to, or something that doesn't best serve your interests. So it's important to understand the partner, and then also basically to protect your interests, but it helps parties to win in a negotiation, because it may not always be 100-100, but if it can be 50-50 for both parties, then it's a win-win for both parties, which is a very good thing. Thank you.
Wow, I think we need a masterclass on this. And I know you'll be readily available to give us more insights. I didn't want you to stop. It's time that stopped you, but there's a question for you. I know that any discussion to do with arbitration on sports couldn't miss CAS or the FIFA chambers. There's a question for you from Sefa Senfuma that you'll come back to give us insights about. He wants to know whether, because you talked about an aggrieved party applying to higher arbitration bodies such as FIFA, DRC, or CAS, would this be permissible where the parties expressly agree to appeal before a lower tribunal? If such party applies stated in the contract, what could be the implication, and how can we get that rebutted? Like I said, we have panelists from across the divide. I want to first rush to South Africa before we go up north. From South Africa, we have Farai Razano. Pauline, I've received very good feedback about your presentation, and that's why I was forced to say we will need a masterclass. As the new committee, we will engage you on how to have that. I want to welcome Mr. Farai Razano to take us through another good area and good topic, which is arbitration in action. Best practices for resolving doping, eligibility, and commercial disputes. I know on call there are members who are passionate about a few of these areas, mostly doping, but I also know that the discussion has just started. Mr. Farai, please confirm if you're on call.
Yeah, I am on call.
Thank you.
Murphy's Law, if anything can go wrong, it will. So I think when we did the test call earlier, everything was
I
working.
know I called you first because I know there's always a blackout in South Africa.
No, well, things have moved to a different level now. We have a
Sure.
government of national unity, which is to an extent delivering. So, and in any event, they will let us know beforehand. So I would have given you my advanced apologies and say at 2 o'clock I will be having power cuts, but be that as it may. Thank you very much for having me. So that I'm not accused of being complicit, I think when you did your introductions, you introduced the next speaker, but used my biography because you continue to say doctor. I'm not a doctor. I don't want
I hadn't read between the lines.
of elevating myself to that level. I'm just Mr. Farai. That's fine. Yeah, look, it's always difficult to go after great speakers because the nature of this topic as well, it's intertwined. So it's very difficult to delineate certain aspects of the discussion. And when you go after great speakers like Senior Counsel Ohaga there, and then Pauline, who just finished now, it makes your task very difficult because both speakers would have touched on the issue of arbitration in sport, or let's start with dispute resolution in sport. And in that process, you can't avoid arbitration. And I think Senior Counsel Ohaga would probably not be keen on the aspect that I'm moving into because, as he correctly stated, mediation is probably always the most preferred or should be preferred in most cases because that way there's no animosity at the end of the day, or there shouldn't be animosity at the end of the day because everyone must get something out of mediation, whereas arbitration, I mean, and now we get into that sphere of the winner must take all, and that's the unfortunate part of sport as well, because there has to be a winner most of the times, and that winner always has to take all. But for the purposes of our discussion, and I do realize that there are time limits here, and for my slot, there are three main aspects there relating to anti-doping, and then eligibility issues, and then commercial disputes. I probably will shelve commercial disputes because most of the speakers will touch on that in any event, and I think Senior Counsel Ohaga has already touched on examples of that sort of commercial disputes, and Pauline as well touched on these commercial disputes. So if we do have time, we can always have a Q&A, and I think some of the questions are already dealing with that issue of where do you go? Is it CAS? Can you agree on a lower appeal tribunal, that, and so forth? But particularly in arbitration for anti-doping, it's almost one of those where, yes, we're discussing it under arbitration, under alternative dispute resolution, but the reality of the matter is that it's in any event already prescribed in the rules. So as most of those who are listening or following would note, that in sports law or sports matters, you're mainly going to deal with two aspects of disputes, or two types of disputes. One would be where there's a pure sporting interest, and then the other one will probably be one that involves economic interest. And with matters that involve pure sporting interest, in most cases, you are bound to have some dispute resolution mechanism that is already inbuilt. be it if it's an issue about discipline and this relates to contravening the rules, you can think of any sporting code that you think of. They would then have specific dispute resolution mechanisms, and in most cases would be a disciplinary tribunal, that sort of thing. And I know there can be murky waters in the sense that sometimes when we talk about alternative dispute resolution, people shy away from the disciplinary aspects of sport because that in your normal or everyday practice would fall towards the criminal aspects, whereas anything else would fall towards the civil process. So in some cases, when you talk about disciplinary processes in sport falling under alternative dispute resolution in the sense that it's prescribed, it raises those questions as to, well, but isn't that quasi or almost like criminal aspect? But the reality of the matter is it's all playing outside the courts. It's all playing outside your normal, traditional or ordinary courts. It's playing out in some tribunal somewhere that it's either in place because of an agreement between the parties, or it's in place because of the regulatory framework where the rules prescribe that you must follow a certain procedure. And that's where we land mostly when it comes to anti-doping measures, because you would have the WADA code at the top, and then nationally you have the national anti-doping organizations, and they would have the jurisdiction to prosecute anti-doping rule violations in most cases. And that, of course, doesn't take away the powers or the jurisdiction of international federations. For example, World Athletics almost exclusively prosecutes all the anti-doping rule violations in athletics, whereas in other sports, you have your National Anti-Doping Authority doing so. So for anti-doping, it's probably one of the best cases or examples of alternative dispute resolution in the sense of at least taking those matters outside the courts. You don't have the sports federation or teams or clubs having to litigate on whether a player or participant is guilty of anti-doping in the courts. They do that before these tribunals. But of course, there are other additional disputes that could arise from that. So if a player is contracted to one of the sponsors, they have these deliverables and they have these terms that they shouldn't be found guilty of anti-doping rule violation. Otherwise, they would have to, the sponsor can cancel the contract, and then they may have to be refunded any monies and all that. That aspect could still arise where one is found guilty of anti-doping and the sponsors pursue them. And there you may have your traditional alternative dispute resolution in the sense that the player or the club and the player would have agreed to how they resolve such a dispute. So two aspects there. The one is the mandatory relating to the actual anti-doping rule violations, which is a matter of pure sporting interest, which is almost exclusively done through an alternative dispute resolution in the sense that it doesn't play itself out in the courts. Then the second layer would be the commercial aspect, and you could, in that second layer, also add issues of fundamental human rights, because there have been cases where some of these rules have been challenged, or some of the procedures have been challenged by certain athletes, and we'll get to that. And most of them have been under the Court of Arbitration for Sport, and then sometimes they spiral. Particularly in Europe, they end up before the European Court of Justice, where these issues of fundamental human rights are discussed. But now to go back to the aspect of anti-doping rule violations or doping and alternative dispute resolution in the sense of the matters playing out before private tribunals, and there's a logic to that, and I think the previous speakers have already touched on that. The biggest being, you want these matters to be dealt with as expeditiously as possible. In some jurisdictions, and I speak of our jurisdiction in South Africa, you probably walk into the High Court and go to the civil trial role and apply for a date, and you probably get a date that is 18 months or even 24 months from now for a trial. So if you were to have these trials in anti-doping measures, for example, that the delay that is that long, sport is a very short career, and for most sports persons, the longer they sit out, the more they lose their fitness and so forth, and may not return to their sport or practice. So that's, in my view, the key or the primary consideration why you would want this to be arbitrated or dealt with outside the courts, and that, to my view, would fall under this alternative dispute resolution. And then the other aspects relates to privacy and that sort of thing, because a lot of personal issues arise in those sort of matters. And because it's private arbitration or private dispute resolution, sports gets to maintain that privacy. And those who follow this sort of trends, you would recall that for the longest part, sports always say they don't wash their linen in the public. They have their own way of dealing with matters. So, but over the years, we've seen sport opening up, more and more people going to courts, or even the sports regulators going to courts. And that's probably was a phase where some of us were pro that. Let's all rush to court because we want transparency. We want the laws to be applied correctly, rather than simply fixating on the rules and say, well, these are the rules, forget whether they affect fundamental human rights and so forth. These are the rules. So there was that age where some of us were pushing for, yes, let's go to court because the courts must pronounce on these things. The courts must give guidance on these things. But we are now probably back on that trajectory of, okay, well, yeah, I think the message has been made very clear. Sport now understands that it is part of the broader society, now understands that the laws of the countries, the constitutions and so forth apply. But let's go back to these private tribunals and ensure that these matters are dealt with expeditiously and so forth. And the other advantage there with anti-doping matters playing out in these tribunals is that they are specialized, and so they don't bring about headaches of, I don't know whether other jurisdictions use the systems of the judge presidents in allocating matters and so forth. Yes, our judges are judges, they're supposed to know the law, or they do know the law, but then sometimes there are these technical aspects that arise from these anti-doping or sporting matters, which is just not what your normal practice of law would entail. And then again, we go back to the issue of assessors being appointed to sit at the bench and assist the judges and so forth. Whereas in those specialized tribunals, they are in fact constituted that way. If I give an example, and that's the practice across the world. In fact, if I give an example of the SAIDS, or South African Institute of Drug-Free Sport, when the panel sits, there's an attorney or a lawyer or an advocate or a barrister, and then there's a scientific specialist, whether it's a medical doctor or someone who understands those things. Then there's someone from an athlete's perspective, and you almost have a tribunal that sits with that diversity, so that if an issue arises that is technical, we don't need to wait and go and get an expert witness and so forth to come and explain these things, because someone understands these matters. So you almost have your own sort of specialized part of the court, in inverted commas, that you need not get to a civil court and worry about whether the court is equipped to deal with this matter, or there has to be those additional matters, additional persons brought to assist the court to reach a conclusion. So before I move away from this doping and alternative dispute resolution in the pure sporting interest and your advantage is there exactly that. Well, first let's summarize the challenges. The challenges being there's always time pressure. You want to finalize the issue so that the athlete knows where they stand. Maybe there are prize monies and medals that must be reallocated because someone has been disqualified. Then there are all these fundamental human rights issues that also arise, which need to be dealt with in those measures. Then there's also the issue of the technical aspect of it, which in my view then make these sort of matters a very good candidate for alternative dispute resolution. Keep them outside the courts, don't get caught in the strict rules of court and processes, but have systems that are designed specifically for that, rules that are designed specifically for that, not caught in when the one party files papers, the other will have to wait for 20 days or whatever number of days before another they file their reply or their answer, that sort of thing, because the environment is fast-paced. But like I said, there's still that aspect that once you move outside the pure sporting interest, you may still have issues regarding to commercial aspects, sponsors now reclaiming their money because someone has been caught for anti-doping. And that generally falls under the general principles of alternative dispute resolution. The parties would have to specify in the agreement how disputes must be resolved, unless if there is a statute or there is a regulation for a specific sport that says you cannot do that. And I think that part of the question that was asked whether parties could agree to a specific lower tribunal to sit as an appellate body. Then the other good thing about the system of this anti-doping rule violation being dealt with in this ADR, even though it's still sort of forced by the rules, it also allows flexibility. And I'm sure many know that almost like at every Olympics, there is an ad hoc committee that's set there to deal with these matters, including anti-doping rule violations. At every tournament or competition, there is an ad hoc committee that's set up to deal with these matters. In some cases, it could still be the normal standing committee, but then its seat gets transferred, well, not its seat really, because in most cases, if you look at, for example, the CAS, even if they came to Nairobi or Johannesburg, their seat would still remain as Lausanne. So, but the point is, you can easily do that. You can easily take the court or you can take the tribunal to the games and resolve these disputes midnight. By the next game tomorrow morning, you know who is the next participant. Although in anti-doping rule violations, it gets a bit technical because there are tests that needs to be done and so forth. But from a general principle point, it's one of the underlying factors that you would have that would justify this sort of ADR in anti-doping matters, in the sense that it speeds up things. Obviously, like any other system, there has to be a bare minimums, and those bare minimums would deal with the best practices. You obviously want independent tribunal members that deal with these disputes, because if there is any suggestion of bias, it undermines the whole system. And for the longest time, ADR practitioners have been trying to sell ADR to the conservatives who believe in just court litigation. Now, if there are bias issues or lack of really technical know-how, competence, you definitely will have challenges there. And again, clear timelines and obligations of the parties is almost the same as the court processes. You have your court rules and all that, they specify certain things. But at least in this ADR setup, they are a bit flexible, because in most cases, there's wide discretions that is always granted to the tribunal members or persons that sit on the board. And from a practical point of view, to make sure that it works, I mean, there has then to be enough education or so that the participants understand, because there's no point in having the best tribunal you can think of in the world, but no one knows how to refer disputes to that tribunal. No one knows where to find them, where to send any claim papers, that sort of thing. At least for doping, that wouldn't be an issue, because the regulator would find you, and once you test positive, they would know where to find you. But I mentioned this as just one of the best practices. The discussion we can have on these matters, I think they are all intertwined. I'm not going to say, well, maybe if anyone has anything to say or ask about anti-doping now, I think we can discuss it at the end. So I'm now moving to the issue of eligibility issues. Traditionally, again, these are matters that would probably be a very good candidate for ADR, particularly under the sports rules or regulations, in the sense that in most cases, they would fall under the pure sporting interest category, in the sense that if it's a eligibility based on sex or gender, and I know I do use that phrase deliberately, because some will argue they are different and so forth, and that's why I say sex or gender. But if you just go on a pure, simple interpretation, if it's a male and female delineation, those are things that would, in most cases, be pure sporting matters, in the sense that we know there's men's football, we know there's women's football, we know there's men's cricket, women's cricket. We know in any track and field competitions, men or males compete against males and females compete against females. But as we know, as the world progresses, these have become more and more, because it's no longer just a matter of left or right. There's now a middle ground, or there's now some ground that's not even within the square. You can't even say middle ground, because of the whole issues of people identifying as a particular sex and people transitioning and so forth. And that has brought about a lot of these eligibility issues. And I think your traditional eligibility issues about the player is not properly registered, therefore they can't play for this team, or the player is not really a national of this country, so they can't play for this national team. Those have taken the backseat role. I think most of these issues that have now become to the fore when it comes to eligibility is this issue of transitions, sex and gender, and so forth. Now, obviously that has brings about headaches as well. There are matters that involve fundamental human rights and so forth. Where should this be resolved? Can mediation, for example, and I say this as an invitation to all panelists and all that are attending, can mediation, for example, be the best platform to deal with this, where I say in 18 months' time, yes, when I came to this platform, I was Mr. Razano, but I've now transitioned. I'm now Mrs. Razano, and I want to participate as a female, while the other participants are saying, well, but no, you can't. I mean, the rules are clear, and some will remember. And I'm not saying that's the same case. I'm using this as an example as to how controversial it can get. If you recall, especially for us down here in the South, you have the famous Caster Semenya issue, where it gets so technical, and one could argue almost that it's almost impossible to mediate such a dispute, because the parties are just far apart. And the same applies to arbitration. Is it really the best suited way of resolving these disputes? or because of the fundamental rights that are involved in these matters? Or are there some of those cases that you would say, well, maybe, just maybe, we go back to the traditional courts, in the sense that they are not limited to a certain degree, because remember, these tribunals are creatures of statute. They just deal with what the powers that are given upon them by the rules, whereas high courts in most jurisdictions have inherent jurisdiction. They are not going to say, we hear what you're saying, but our hands are tied. They can deal with almost anything. But at the same time, you also have the issue of, well, but this transcends boundaries. If we, arbitration may be the best, because once it sits before the Court of Arbitration for Sport, we know that whether they deal with a South African athlete, they deal with a Kenyan athlete, they deal with a Moroccan or Mozambican, they are going to apply the same rule as individual courts in individual countries may deal with these matters in different ways. So while we push for ADR in some of these cases, eligibility issues then bring about this sensitivity of the issues that are under consideration, and whether that could be best placed, ADR could be best placed. I still submit that yes, ADR probably is the best place in the sporting context, because remember, we are gathered here to discuss in the sporting context. And in fact, I think for my bit, it's actually having ADR in action. Yes, because some of those rules that may arise when it comes to eligibility issues, disputes that would arise when it comes to eligibility issues, relates to what the rules say can be done. In a general society, that might not matter anyway. Whereas in the sport, it would say, certain levels of testosterone and so forth. If you exceed that, you can't participate. And what best place to deal with those matters other than specialized ADR tribunals? In this case, whether it's under the sports governing bodies rules, or it's outside, in the sense that you go on the appellate level, where you go to the Court of Arbitration for Sport, which by its name is the Court of Arbitration for Sport, and its jurisprudence is rich when it comes to these matters. And all those other general principles that are mentioned, or others have mentioned, why alternative dispute resolution is the way to go, would apply anyway. And as I said, the third category being commercial disputes, and this I don't want to spend time on it, and I would rather leave it for discussion, because it's mainly general principles of alternative dispute resolution, in the sense that what other speakers have touched on, or other speakers are going to touch on, is probably going to apply, in the sense that you want to resolve these disputes before tribunals that are quick or expeditious. You want to give the parties the autonomy to prescribe the process, so that at least they don't wait for 24 months or 18 months before their dispute is resolved. You want the parties to have certainty, particularly when it comes to knowing how the disputes in that environment are dealt with, particularly in this sporting environment, because and I'm not discounting what precedent in the normal courts would be, but as a practitioner myself, there's nothing that is really concerning as you are busy arguing a matter, and then someone then just raises a matter and say, well, as was held by the court in the Johannesburg Stock Exchange versus so-and-so Pty Limited. And then you spend hours and hours having to dissect pure corporate law principles or pure company law principles, just arguing a simple matter of whether the image rights have been transferred, or the image rights at least have been secured by one party from the other. Yes, you want certainty when it comes to the law, but at the same time, you don't want these overly technical matters to arise. So this ADR in the sporting context would be the best place to deal with those matters. But as I said, and I'm closing on this, it's definitely hierarchical. Some of these disputes, you may battle to follow the hierarchy because sport emphasizes winner takes all principle, but you probably want, as Senior Counsel Ohaga said, start with the mediation and then rise. And if all else fails and parties must now fight, well, then so be it. But then that fight must play out in the alternative dispute resolution framework rather than your traditional litigation. And that obviously allows all sorts of other advantages, flexibility, and so forth. Parties agree to appoint a certain arbitrator and those sorts of things. You can do those things virtually and other general principles or other advantages of alternative dispute resolution. So for the fear of repeating myself or repeating what the other speakers have touched on, I think I'll stop here, and then if there are specific issues, we can always have those in the form of a discussion. Thank you.
Thank you, Mr. Farai. We shall keep engaging. Like I said, our sports law committee has just been reappointed, and we hope to have very engaging discussions. I decided to call Dr. Emmanuel last because I know dodging traffic in Lagos is a sport. So he knows how to manage time, and in the next 10 minutes, he will take us through the future of ADR in sports. Doctor will guide us. Can ADR stop the politics in sports? The example that Senior Counsel gave of the Golf Union and the Golf Federation is already happening in Uganda right now. Federations have up to 20th June to re-register with the registrar now, who is the Secretary General of the National Council of Sports. But confusion has already started. The minister in one particular example is the Boxing Federation. The Boxing Federation that has been largely in charge of amateur boxing is the legit federation to take on sports. But then we have a professional boxing commission that also says we are the ones mandated to control professional boxing. But the minister insists there should be one federation in charge of a sport. What is the future of ADR in sports? The minister has called these parties. We have attended, because I've been in the meetings. We've attended 2 meetings with the minister, but still the impasse is still on. What is the future of ADR in sports? Doctor, from a scholar and practitioner point of view, please guide us in the next 10 minutes, and we shall use the last 10 to 15 minutes to have an open discussion, more so on statutory arbitration, which is the issue right now in Uganda. In this discussion, we have on call my friend Ivan Ojakol, who is also very passionate about sports law and practice in Uganda here. We've had a side chat saying what is happening right now. Today, because arbitration has been, the law provides that even in the constitution of federations, there should be arbitration. There should be an arbitration clause, but we don't know how to go or how far we should go about it. So in this discussion, as you take us on, Doctor, we shall need to know more about how to embrace and how to get the best out of statutory arbitration in sports. Thank you.
Yes, good afternoon. It's a pleasure being here with you today again. I like to appreciate the platform, the opportunity given to me to contribute to this year's discussion again, and my co-presenters and everyone listening and following across the continent and beyond. the subject of ADR in the sport industry is always an exciting one because you see, that is the way to go. And the earlier we embrace this, particularly for us in the continent of Africa, and begin to put together a legal framework for its workability, the better for us so that we are not left behind. And I'm glad today hearing from our various speakers the effort they've made in getting or putting together a structure and institutionalized arbitrations or other ADR mechanism in resolving their sport dispute. In legal jurisprudence, as lawyers, we know that there are various instruments for the resolutions of dispute. The dispute could be resolved through the instrumentalities of litigations and judicial interventions, arbitration, mediation, negotiation, conciliations, and other hybrid dispute resolution processes. But there is no doubt about the fact that listening to our speakers today, I think the consensus is when it comes to sport dispute resolution, it is ADR that seems to be gaining momentum as the dominant method of dispute resolution, not only for us in the continent of Africa, but globally. And this is because um, today the sport industry is becoming a one commodity market. And what do I mean by one commodity market? I mean, it's becoming a globalized industry where everybody have to participate in one in the market, as it were, is centrally. And you agree that football on its own have even been globalized even before now by the dominant rules of FIFA, right from the international to the continental and to the various FA federation of each country. So it is no doubt that ADR is gaining momentum in the sport industry, and the Court of Arbitration for Sport is now recognized as an emerging leader in international sport dispute resolution. The various speakers who spoke before me have actually itemized the various advantages of ADR in the sport industry, and we need not repeat them again and save some time. But permit me to just emphasize again that the idea of ADR in the sport industry, beyond all the advantages that have been mentioned, is this that the football industry, no matter the commercializations of the industry and no matter the money and the dollars in the industry, one thing still remains about sport. It is that sport is a means of recreation. It is a means of national integrations, unity, cohesion, cohesion, and togetherness. And beyond the money, beyond the dollar, beyond the industrializations and the commercializations of the industry, the truth still remains that sport is beyond money. So it therefore means that dispute in the sport industry must be resolved within the family of sport. And sport generally is tied to age, is tied to time. And if you say commercial dispute should be resolved expeditiously, I tell you, then for sport, it should be much more because these things sometimes are time bound, and for the athlete, they don't really have many years to be out of participation, because some tournaments are periodically, some are as much as even 4 years, 2 years, and these things are tied to age. So having said this, I really want to pay attention to the area of my topic, talking about the futures of ADR in the sport industry. Well, basically, in speaking on the future of sport in the future of ADR in the sport industry, basically, as topic assigned to me from the aspect of technology and as well as the issue of equity, which have become a global discussions in our contemporary society. Now, talking about the technology impact on ADR, it is no doubt that technology have really offered so much for impact and leverage that practitioners of ADR can use. And that is gladdening because today we could talk about online dispute resolution, ODR, so which give us a borderless legal practice as lawyer, that you could stay in the comfort of your office, just as I'm staying in the comfort of my office all the way from Abuja, Nigeria, and I'm speaking to colleagues across the continent of Africa. That is technology, and that is massive. And then number two, talking about the artificial intelligence leverage that comes with the technology into the sport industries and in resolutions of sport dispute. Number three is the digital and electronic evidence, and all this leads to one thing, and that is it makes resolutions of disputes to be faster. It improves accessibility, transparency, accountability, and bring a global perspective to it. Although there are also challenges that come with the impact of technology on ADR in the sport industry, but I will address that at the end of my paper. And secondly, the issue of equity in inclusions of all. You know, the one thing about the sport industry is the diversity, and this particular area is challenging to ADR because we have these diversities across the nations and across the continent of the world, and that, you know, in its own becomes a very big challenge, which is particularly where I'm going to be spending more time on my paper. But before I get to that, let me just advise again, just like as one who have done extensive research on ADR in the sport industry, that for us today, as we gather here, let us not forget that, especially those of us who are lawyers, that in practicing ADR in the sport industry, we must have this commitment to continue to educate stakeholders as to the process and the advantages of ADR in the sport industry, so that matters of sport are not taken to court, because when they do, they drag us back for many years. So let's continue to advocate for ADR in the sport industry. Let's have advocacy for it across the countries of Africa, so that we could secure not just arbitration, but mandatory and statutory arbitration. Because when you have statutory arbitrations entrenched into the constitutions or the legal framework of the country, it makes the arbitrations to become the only options. So in which case, it take away resort to court and judicial intervention, which is not a global trend, because the global trend now is ADR in the sport industry, particularly sport arbitrations and sport mediation. Number two, practitioners of ADR in the sport industry must be mindful of media scrutiny and the need to adopt a neutral stand, the need to maintain confidentialities in matters relating to issues handled in the sport industry, because this is an industry that is exposed to media scrutiny, and journalists are going to come after you. They are going to ask you questions. It is important that within the bounds of the legal framework under which the mediations or the arbitration is undertaken, that information gained by sport arbitrators, by sport solicitors, should be treated with utmost confidentiality. And then we should not forget to continue to train and continue to train, so that we could maintain the best international practice and be in tune with global practices that will enable us as a continent to be a key participant in the sport industry. As I wrap up my presentation, the area I really also want to point attention to, so that some of us here who could do advocacy, who have the platform, who have the opportunity, we could work towards is as the challenges for ADR, the future challenges to ADR in the sport industry. Number one is this issue of cultural differences and the different perspective of social justice across the continent of Africa, and not just across the continent of Africa, I mean globally. For instance, in the sport industry, we have transgender issue, and each continent or each country have different perspective to transgender issues, perhaps based on cultural differences or religious bias, issues of sexism, issue of bisexualism, issues of racism, etc. in the sport industry. So that is the number one challenge. How are we going to go around this? But two is the impact of artificial intelligence and the challenges associated with this, particularly the advent of artificial intelligence in ADR in the sports industry will also occasion the challenge of data protection, security, connectivity, infringement of privacy, and personal information. How are we going to work on that? The number three, we need to, especially for us in Africa, we need to continue to advocate for an acceptable framework for recognitions, enforcement, and compliance with award and decision obtained in ADR, because many of our countries, the continent of Africa, will always wants to lean towards judicial interventions and court, unlike what we are saying that in the sport industry, that ADR is the way to go. So we find a way of having a framework for recognition, and not just recognitions, enforcement and compliance, because it's possible for a court to recognize an award and yet refuse to enforce the award, particularly when we begin to bring in the issues of national sovereignty vis-a-vis international global sport law. Number four, the issues of the imbalance in the strata and stakeholders in the sport industry. Sometimes the federations are powerful, the governing bodies are powerful, and that is caring to investors and sponsors who are the people actually going to bring the money. As much as we continue to canvass for sport marketing and commercialization of sport in the continent of Africa, we must be mindful of having a framework that will balance, that will create a balance in dispute resolution between the athletes, between the federation, the governing bodies, the investors and sponsors, and private intervention vis-a-vis government intervention. Number five, the global benchmarkings of ethics and ethical consideration in the face of innovations in the sport industries and ADR to ensure fairness, transparency, accountability. And the number six, I will strongly canvass that we should advocate for institutionalized institutionalized arbitration, something akin to the Court of Sport, the National Court of Sports, a court for sport across the continent of Africa. And some of the countries in Africa are already doing well in this, and they are really pesetting in this, and that is gladdening. But the same call is made just beyond the East Africa countries, the West Africa, the South, and the North. And for us as a continent of Africa, let our sport governing bodies rise up to this and find a way of continuing to advocate until this is done across the country. Because one thing about ADR in the sport industry is the not doing of a country can have impact on the effort of another country, especially we talk about the cross-cultural, cross-movement of players across the various sports, not only continental level, but even across intercontinental level. So I really will advocate that we pay attention to these few challenges that I have mentioned today on the futures of ADR in the sport industry. One more time again, I want to thank you for giving me the platform to share with us today. I'm mindful of the time given to me, and I think I've finished my 10 minutes. But obviously, too, I think I have talked in summary to the papers I have put together. Thank you so much for giving me the platform to be part of this meeting today, and I will still hang around if there are questions that you want me to contribute to. Thank you and good afternoon, everyone.
Thank you, Doctor, and I thank you for coming up with solutions at the end of your presentation to the problems that we could be facing, or having approaches that we can have to get a better way forward. I wish to call back Senior Counsel John Ohaga. You had about 2-3 questions that you needed to address us on in the Q&A. We wish to share into your wisdom, Senior.
Philip, can you remind me what the questions are? Are they in the chat? Maybe they're in the chat or they're in the Q&A.
Yes,
Okay.
in the Q&A.
Yes.
But
so the first question relates to legislating on mandatory ADR. Well, I can tell you that that is what the Sports Act of Kenya has effectively done. It has required sports disputes to be resolved primarily through ADR. Of course, it has delineated the jurisdiction of the sports tribunal. And so within the confines of the parameters of that jurisdiction, the tribunal will largely resolve sports disputes through ADR. And we have found that it is effective. We have found that it is efficient. And to demonstrate that, I will give you a very quick example. So there was a dispute within the athletics body in Kenya relating to governance. That dispute, for some reason, the petitioner decided to frame it as a constitutional issue and went to the High Court. The High Court finally rendered its decision after 6 years. The decision was then appealed to the Court of Appeal. The Court of Appeal rendered its decision 2 years later, so that's 8 years. And now, one party is trying to obtain leave to go to the Supreme Court, a matter which the Sports Tribunal would have resolved in 6 months, has taken 8 years through the court process. So that's one very quick example I can give you. I think that mandatory ADR is really the way to go with sports-related disputes. And having served for 10 years at the Sports Disputes Tribunal, I completely endorse it. Whether it is arbitration or mediation or negotiation, they should be resolved through ADR. And that ties into Henry's question, which is how willing are the stakeholders to embrace ADR in sports-related disputes. We have found that stakeholders are actually, once they appreciate the advantages of ADR, once they appreciate speed and efficiency and cost, right? And once they also gain confidence, confidence is a very, very integral part of the dispute resolution process. Once they gain confidence in the mechanisms put in to resolve their disputes through ADR, then you will find more and more users. The, the docket of the Sports Disputes Tribunal is full, you know. And generally, when I was chair, we would have 3 panels dedicated to hearing different disputes and also developing jurisprudence. So the jurisprudence of the Sports Tribunal is now referred to, now used authoritatively, and now even discussed by federations at their meetings, by sports people, and used as a guide for them to determine whether or not they should actually come to the tribunal in relation to a matter. And where they view the dispute as having a precedent, you may very well find that they determine that that is the way they should resolve the dispute. So stakeholders are willing. Stakeholders look for the same thing any stakeholder would look at in an environment like this: speed, efficiency, cost, trust, integrity, and satisfaction eventually. So that would be my answer. And then the other question by Ivan actually is whether sports federations, whether they objected to our jurisdiction. Yes, they started off by objecting to our jurisdiction. We were then able to craft decisions which defined our jurisdiction with clarity. In certain areas, I have to confess, we extended our jurisdiction because we appreciated that, we were of the view that it was in the best interests of the sports ecosystem. In fact, there are federations which went to court and came back to the tribunal. Because you can imagine if you go to court in relation to a matter and 6 months later you still haven't been heard, and you're aware that a similar matter has gone to the tribunal and has already been resolved, what is the natural reaction? Is to come back to where you will have an efficacious remedy with specialist resources, rather than to go to court where the specialization and the sensitivity is also absent. So, for instance, at present, I know, even though I'm no longer on the tribunal, there are disputes relating to the elections for NOC, the National Olympic Committee of Kenya. 4, 5, at least there are 6 suits, all of which have been filed at the tribunal, seeking to resolve or unlock disputes around candidacy, disputes around criteria, disputes around who is eligible to vote, and so on and so forth. So, Ivan, the answer is yes. Sports federations are now come before the tribunal. When they are sued, they come before the tribunal, they instruct counsel, and they participate. But the other thing I have to say is that we have also engaged, and I continue to say we, because I continue to think of myself as still being on the tribunal, but we did a lot of public education. We would go to federations. I attended numerous interviews at radio and TV stations to talk about the tribunal, its jurisdiction, and to just bring knowledge and understanding to federations, so that by the time they came to the tribunal, they were satisfied that they would get what they needed. And the other thing is to make yourself open and available. I did not behave like a judge, escape into my chambers straight after a hearing. If the press wanted clarification around a decision, I would explain it. If parties wanted clarification as to how a decision had been entered into, or what the considerations were, or what the parameters were, I would explain it. If there was an award ceremony, like we have the Sawyer Awards, Sportsman of the Year Awards, I would attend and be visible so that you fraternize. And it doesn't take away from your impartiality. It just means that they see you as available to them, as one of them, as a sports person, serving their needs. And so those were some of the strategies that we were able to deploy to ensure that we had their confidence. So Philip, I hope that answers the question sufficiently.
Thank you, Senior Counsel. And I think we had one question from for Mbanza, if she's still online.
Yes, Pauline is still there.
Yes, Pauline, you had a question which I wanted you to respond to.
Yes, please. I saw a question that spoke about if parties have agreed to apply. Okay, let me just read it directly instead of paraphrasing it. Ma'am, you talked about an aggrieved party applying to higher arbitration bodies such as FIFA, DRC, or CAS. Would this be permissible while the parties expressly agreed to appear before a lower tribunal? If such party applies to one not stated in the contract, what would be the implication and how can they be rebutted? Firstly, the precise answer is yes, but of course with exceptions. And the only way that it, regardless of the contract or the agreement, the only time a party can actually apply to a different tribunal that has not been cited in the agreement is when that tribunal does not have jurisdiction or is not competent to actually handle that case. And this is very, very common in in AMA tribunals, that is member associations of FIFA. Their tribunals sometimes, if not most times, are not always competent to handle disputes, especially if the disputes involve international players or clubs or coaches or agents. So most of the times it has to be taken to the FIFA DRC. An example in cases, I handled a case to do with a South African club that signed a Cote d'Ivoire player, and these people in the contract practically said that they had to take any dispute that arose from that agreement to the South DRC. So it was something that could not be done because the regulations are very clear that the MADRC cannot handle a dispute that has an international aspect or international party. But then, regardless of that, going on to look at the other aspects, FIFA does put out qualifications for every single for DRCs, for AMAs to set up DRCs. So if a DRC does not stand, that is not up to that is not up to that level or is not competent in terms of what has been provided for by FIFA, that party can actually take to a different DRC. Sometimes the contract may not even say that you have to take it to FIFA. They may this may most of times happen in cases whereby clubs or sports entities are not really very competent, so they will say that you can take it to an ordinary court. Most of the times, actually, that is going to happen sometimes, but a party can actually take it to a DRC and they can argue it there because as long as it has the right jurisdiction to handle the case and it is within the spot that it's supposed to be taken to, they can actually take it there. It just has to make sure that while they have not taken it, it's not a competent place and they're not assured of justice being served. So practically the answer is yes, with those exceptions.
Thank you, Pauline. And I think we don't have any other pending questions. We can call this discussion to an end. I wish to thank all the panelists, and I wish to also ask that you continue to bear with us. We've just had the ELS Sports Law Committee appointed last week. So we hope to work with you along the way so that we can have more discussions. I'll be pushing for having more master classes in the different areas of sports law, so that we can get deeper insights into your expertise in the different areas. And I also want to thank the zeal that you have to always present when we reach out to you. We don't want to miss out on the knowledge that Senior Counsel and Dr. Emmanuel have shared. We need to have it on record. So these recordings are shared on the ELS YouTube channels and also shared in members' emails. So going forward, it will be a continuing discussion, and we shall be calling on people, and I think we always have a monthly, if not bi-monthly, discussion on sports law. The ELS Secretariat has accepted that, and we have been doing wonderful, and going forward, it will be all the best. I wish to call this meeting to an end, and we can leave at leisure.
Thank you very much, Philip. Thank you for convening this. It was our pleasure, and we look forward to interacting.
Thank you.
More in the future.
Thank you so much, and God bless.
Thank you very much, and keep well, everybody.
Thank you very much.